Hello entrepreneurs, it's Michael Mort with Argent Place Law, the law firm for entrepreneurs. So I want to talk to you about a very special kind of contract that you will have with your partners. When you form an LLC, you're going to have, if you form an LLC with partners, you're going to have what's called an operating agreement. You'll have some kind of an agreement with your partners about how the company is going to be run, what happens if one person dies or becomes incapacitated, how you're going to share profits, who's going to manage the company, all kinds of things. That's called an operating agreement if you're an LLC. If you form a corporation, it's the same kind of thing. It just happens to go by the name shareholder agreement. But mostly we form LLCs, so I'm going to continue to use the word operating agreement. All right, so when you first start out, this is all verbal. You say, hey, let's form a company together. Let's be equal partners, or let's be 60-40, or whatever the thing is, and we're going to have fun and make a lot of money. And that's pretty much as far as it goes. Sometimes you might say who's going to run the company, or we're going to have some kind of an agreement, or we're making certain kinds of decisions, but you just do it verbally. All right? When you don't have any money to start with, that's what you do. But the problem is, if it's a verbal contract, nobody can decide what was actually said. There's no record of what was said, and there can be some disagreement later on. Okay, so you decide, well, the next best thing is we're going to go cheap, and we're going to download something from the internet. By the way, you can just have like a very, very basic operating agreement. Even if you don't have an agreement, before you even download something from the internet, you don't have an agreement, a written agreement, then it goes by your kind of verbal recollections, and the things that you didn't cover in your recollections of your verbal agreement are going to be covered by the default rules of the state. And the default rules may be something that you don't like. I've already talked about in a different post, or the situation in which you each contribute different amount of capital. But anyway, the point is that there are a lot of default rules that you may not be interested in being held to. Okay, so the next best thing is you say we're going to go cheap, we're going to download something off the internet. That still has a lot of defaults in it, right? They may ask you a few, the download artificial intelligence program may ask you a few questions, but nevertheless, they're pretty much default. They don't ask you to tell you to go in and modify this or that, the other thing. So I'm going to call that another default kind of operating agreement. The third one is what I call a negotiated operating agreement. You actually talk to each other about what the contents will be, and best under the direction of somebody that knows what they're doing. I've seen a lot of operating agreements like a lawyer. A business lawyer, especially one who specializes in new business startups like we do, we've seen a lot of deals. We've talked to a lot of companies, or people that are forming companies. I and myself have formed companies for my own benefit. Years ago, a software company with a partner. So I know what goes into these things, and I know what can happen if you don't talk about what the important elements are. So, and a perfect example is, what happens if one of you dies, becomes incapacitated, simply loses interest, has an opportunity to move across the country and no longer can participate? That would be covered under a buy-sell agreement or a transfer agreement. It's usually the largest section of an operating agreement, but there are many other parts. Now, an operating agreement is not required. It's not required by the state. You can rely on default rules of the state. It does not have to be written, especially in Virginia, where it specifically says it doesn't have to be a written operating agreement. So none of this is legally required. It's simply good business practice. So when you start out and you don't have a lot of money, I can understand taking a risk and just having some verbal agreement or something you download off of the internet. But have something in writing with your partner that says, in a year, when we start making money, or whatever, we have some money, we're going to review this, and the one that we're using now, this verbal agreement or this one that we downloaded off the internet, is going to become void in a year, and we have to negotiate a new one. We're looking out for you, entrepreneurs, and we want to make sure you succeed. We don't want you to get into trouble with poorly written or non-existent agreements. So call us or call some other business attorney to make sure that you have yourself protected amongst your partners. I'm Michael Mort with Argent Place Law, the law firm for entrepreneurs, where we're looking out for you. Thanks for listening.